And it's kind of a basic question, but in the end, a DUI is, in Florida, the crime of driving under the influence of alcohol. In the past and in other places, it's known by different names. It could be a DWI, which is normally driving while intoxicated. Sometimes people use the term U-ball, which is driving with an unlawful blood or breath alcohol level. But in Florida, DUI basically is defined as driving under the influence of alcohol or a controlled substance when you're affected to the extent that your normal faculties are impaired. Basically, there's two ways that the state can prove that somebody was guilty of a DUI. They would have to show either that their breath or blood alcohol level was a 0.08 or higher normally, or they could prove that the person's normal faculties were affected to the extent that they were impaired. And impaired doesn't mean you were falling down drunk, it's just a diminishment. So sometimes people don't realize the DUI can be proven two different ways. Now that's challenging because the state doesn't always have the evidence to prove that somebody was guilty of a DUI. So just because you've been arrested for a DUI doesn't mean the state can prove you guilty. Oftentimes people refuse to take a breath test. If you refuse to take a breath test, then obviously there's no breath test. So they would have to show that your normal faculties were impaired. The problem is everyone's normal faculties are different, and there's many different things that can affect what somebody's normal faculties are. Some people just inherently have poor balance. Some people always have red or watery eyes. Some people don't speak well. There's a lot of different things that can affect somebody, and just because they are the way they are doesn't mean they're guilty of a DUI.